like he worded. All right, the next case is number 69030, Mason William Herring. All right, Ms. Cates, whenever you're ready, please speak up loudly and clearly.
I'll do my best. I am going to forego an opening statement, if that's all right with the board, and I'll just jump right into the presentation. Okay? Perfect. And may it please the board. This is a compulsory discipline matter brought against Respondent Mason William Herring and is based on Respondent's two separate felony convictions. The first for assault of a pregnant person, the second for injury of a child under 15 with bodily injury. Subsequent to Mr. Herring's convictions, Respondent was placed on deferred adjudication community supervision for 10 years. Additionally, Respondent was ordered to be confined for 180 days in the county jail as a condition of his community supervision. Petitioner filed its petition for compulsory discipline on March 4th, 2024. Thereafter, Mr. Potter asked that the hearing be continued for the April setting so that his client could attend. However, his client is not here today, so we are here today to have this matter be heard. Petitioner filed its first amended compulsory discipline petition on April 24th, 2024. Respondent was personally served with the first amended petition and notice of hearing on May 15th, 2024 by Roberta Cuellar, a deputy with the Harris County Constable Precinct 1. Proof of service has been on file since June 14th, 2024. Regarding Mr. Herring's conviction on November 2nd, 2022, Respondent was charged by indictment with assault of a pregnant person in cause number 177-2106 in the 185th District Court of Harris County, Texas. On December 14th, 2022, Respondent was charged by indictment with attempted injury to a child with serious bodily injury in case number 179-8932 in the 185th District Court of Harris County, Texas. On February 7th, 2024, a judgment of conviction by court, waiver of jury trial, was entered in cause number 177-106-01010. Respondent pled guilty to assault of a pregnant person, a third-degree felony. Thereafter, Respondent was placed on community supervision with 180 days to be confined in the county jail. He was also ordered to pay court costs, and there were many other terms of his conditions of his probation. On February 7th, 2024, a judgment of conviction by court, waiver of jury trial, was entered in cause number 179-89-32-01010. Respondent pled guilty to injury of a child under 15 with bodily injury, a third-degree felony. Again, Respondent was placed on community supervision for a period of 10 years and also ordered to be confined to county jail for 180 days, also to pay court costs and numerous other conditions of his probation. At this time, I'd like to offer the following exhibits into the record. Exhibit 1, a certified copy of the indictment entered in cause 1772106, styled the State of Texas versus Mason William Herring in the 185th Judicial District Court of Harris County, Texas. Exhibit 2, a certified copy of the indictment entered in cause number 1798932, similarly styled. Exhibit 3, a certified copy of the judgment of conviction by court, waiver of jury trial, entered in 1772106-01010. Thank you for bearing with me for these numbers. I just want to make sure, because there are two different convictions, that the record is really clear. So I'm almost done, I promise. A certified copy of the judgment of conviction by court, waiver of jury trial, entered in cause number 179.
Is this exhibit 4?
Yes, sir.
All right.
179-893-201010. Exhibit 5 is my original affidavit attesting that respondent is the same person as the person identified as the defendant in the 2 underlying criminal cases. Exhibit 6 is a certified copy of the original complaint in case number 1772106. And finally, Exhibit 7, an original certificate from Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated October 9th, 2024, indicating that respondent is currently authorized to practice law in the state of Texas. At this time, I ask that 1 through 7 be admitted.
All right, do you have any objection, counsel?
Your Honor, I have objections to Exhibits 1 and 2. And what is number 6?
6 is the complaint, and it's the Exhibit 6 to my briefing, and you did object to it in your motion to object.
And that's what I had in my notes.
Yes.
Okay. And number 6, I object to all those. We've submitted briefing on this, but basically they're hearsay indictments are simply allegations. They're not proven. And so we would object 1, 2, and 6.
All right, I've reviewed your motion. I understand your objection. It's overruled. The exhibits are admitted.
May I approach? I have to get you a 6. I'm going to briefly walk through my brief and my briefing and case law that I've given you in this matter, as we are requesting the disbarment of Mr. Herring pursuant to his felony convictions, which we do believe, as the Chief Disciplinary Counsel's Office, fall under serious and intentional crimes. The requirement under 106G in the rules and the definitions state that a serious crime includes felonies of moral turpitude. The case law is abundantly clear in Texas that a man committing an aggravated assault against his wife and or his child, specifically in this case minor, is a minor child is what I meant, is a crime of moral turpitude and has been held so for a very long time. I really think this goes without saying, but I'm going to say it because it needs to be said. I'm not precisely sure how you can get around this case being a crime of moral turpitude. Assaulting a pregnant individual has got to be one of the most heinous crimes, and this is, I guess, a personal belief, but a pregnant person who's carrying a child to be assaulted by her husband, how we cannot find that a crime of moral turpitude with the case law and with just the facts of the case seems difficult for me. And thankfully, Mr. Potter and respondent don't seem to be arguing against the convictions, either one of them being crimes of moral turpitude. They do, however, argue whether or not the crimes required intent. And under the way the analysis of compulsory discipline and intent as it's defined in 106GG, you look to specifically to the penal code statute and the elements of the crime, and that's where you're supposed to, in terms of a moral turpitude analysis, that's where the analysis should stop. But my argument is that is not what has been argued or found in the case law when it comes to the matter of finding intent. There is nothing in Duncan, in Locke, in any of the cases that have been cited by Mr. Potter that states that you can't look to the other documents in this case when looking at intent, only when you are looking at moral turpitude. That is specifically what Locke and Duncan hold. The matter of intent is, by its very nature, a factual question. For every single case and every single penal code violation to be brought against someone, the jury and the fact finder have to look at the facts surrounding the circumstances where the crime was committed to determine whether someone has intent. Unless you get very lucky and the respondent or the defendant tells you, I definitely did that on purpose. But that doesn't happen very often in criminal cases. Presumably, if you're defending yourself, you're defending it was not intentional. In the case of assault, I think a hypothetical might be helpful. It is possible to commit an aggravated assault recklessly. That is in the penal code statute. But you do something, the nature of which Mr. Herring committed, perhaps you have rat poison left out in your garage and your 2-year-old finds it, ingests it, and passes away. Perhaps you are recklessly negligent or you have a reckless disregard because you left it where your 2-year-old could find it. That is not what happened here. This is an aggravated assault caused by Mr. Herring's intentional, willful poisoning of his ex-wife to induce her abortion. How do we know that? Because the documents tell us. The documents literally say that he did so intentionally, and that's found in the indictments, in both of the indictments. And so for Mr. Potter to come and argue on behalf of respondent that it's possible that this wasn't done intentionally, or it could be found that he didn't do it intentionally, is disingenuous and dishonest, and asks you to ignore findings that exist in government documents from his case. It is true. It is possible to commit an aggravated assault with reckless disregard, without stated intent, statutory intent. It is possible to do that, but that is not what Mr. Herring did. And that's also why we have these cases to talk about penal code provisions that fall under compulsory discipline and whether or not they meet all of the required points, the serious and the intentional requirements. Again, I'm not saying that aggravated assault is not possible to be done without intent. What I'm saying is we're here to talk about Mr. Herring and what Mr. Herring did. And what Mr. Herring did is poison his ex-wife with the intent to cause harm. Mr. Potter has then further argued that Mr. Herring is eligible for suspension as opposed to disbarment. I disagree. I think the case law states that he should be, it says he shall be disbarred unless you find in your discretion to not disbar him. Mr. Potter has quoted the case law that says, as a term of the probation. I still disagree with the intent of the drafters behind what he is saying, but the words are there. So if this board finds that you have discretion to do something other than disbar Mr. Herring, I think it is incredibly important for you to think about the consequences of that kind of decision. That means that other attorneys could do something similar, something heinously similar, and end up with a probation instead of a disbarment. Mr. Hunt-Palmer came up here and talked about the Asazi and Filipov factors. And in fact, Mr. Potter briefed, he submitted a brief talking about the factors. He didn't explain how we got there from the case law, but he is right in saying there are several factors for the board to consider when deciding to use their discretion or not use their discretion to suspend someone versus disbar them. And I'd like to briefly walk through a few things that Mr. Potter has asserted. Mr. Potter states that this crime was not directly related to the practice of law. On its face, that is a factual statement. But it is related to the practice of law. Because we wouldn't be here if Mr. Herring wasn't a lawyer. And so Mr. Herring, because we wouldn't have jurisdiction if Mr. Herring wasn't a lawyer, is my point. And so we wouldn't be, his punishment would be done in so much as, the criminal conviction. I do believe he's out of jail at this point. He only served 6 months for this. But I think it is important to say, if this person gets put on probation instead of disbarred, you've now got a lawyer practicing who intentionally poisoned with the intent to commit serious bodily harm to his wife and his unborn child. I think that is a detriment to the profession of law. I think it degrades the kind of people we have who are entrusted with taking care of other people as their primary job. The conduct of the attorney during the compulsory proceeding and the attorney's credibility under oath. As you can see, Mr. Herring is not here. Mr. Herring has exhaustively briefed this issue and wants to stand on his briefs, and that is his prerogative. But he's asking you for mercy. He's asking you as a board to believe that he should still practice law, and that would be a mercy from you. It would be a use of your discretion to not disbar him, To me, he should be here to face you, to ask you for that. He should also be here to allow you to ask him questions about maybe why he did this, how he did this, why he thinks it's okay to continue being a lawyer as he has done this. I truly think it's a disrespect to the proceedings, and I think it is a discredit to his victims and to any potential clients he may have in the future, because he's going to have to answer this, right? I mean, if you Google Mr. Herring's name, you get Nancy Grace interviews, and you get lots of media. So his clients are likely to know. And I feel like his future clients deserve for him to have been held fully accountable if he is going to be able to continue practicing law. It goes without saying, seriousness and circumstances surrounding the attorney's conduct. I don't know, I'm positive there are worse crimes, but this is really a serious conviction. It's a serious set of actions, and it's something not only as a profession we need to take extremely seriously, but it's incumbent upon us to really examine Mr. Herring and his actions. As I said, damage to the profession. I think the fact that a lawyer in the media has done this, it's not a good look for the profession as a whole. I understand not everybody can be great people, and I'm not even saying that Mr. Herring isn't a good person. I know he made some choices, and he has to live with those choices, but now we have to live with the decision of deciding what to do with Mr. Herring as a lawyer. Mr. Potter, I apologize, is Harry Potter. Mr. Potter says that there was no profit to the attorney. But then the question remains, why did you do it at all? I mean, when you did it, there had to have been some reason for it, and whether or not you claim that as a profit, I just find it interesting that he points out there's no profit because he didn't ultimately accomplish what he set out to accomplish. Avoidance of repetition, this kind of goes back to what I was talking about a minute ago, which is we don't want other attorneys to think that this is something they can attempt to get away with and then still be able to practice law. I also found it interesting at some point and I can't remember exactly which element that Mr. Potter was referring to, but he points out that this was Mr. Herring's ex-wife, and also that then led to a 2-year, very tumultuous divorce. I'm not precisely sure how that is a mitigating factor. I assume that if I was the ex-wife going through this divorce, it would be a very tumultuous divorce as well. All I'm asking you to do here today is hold Mr. Herring accountable. That's really what this comes down to. I'm asking for you to disbar him because I do believe that is the right thing to do. But it is within your discretion to make those. And I do not envy the decision you have to make. But I ask you to please go into it with an open mind, reading all the case law and really weighing all of the different factors and all of the repercussions of this decision. And we ask that you disbar Mr. Herring. Thank you.
Any questions of petitioner's attorney?
I have a question.
Yes, sir.
What constitutes the record of conviction in these cases?
I have case law that states the record of conviction, and if you allow me one moment to find the actual statement. I will tell you that the indictment and the judgment are both part of the records of conviction, and I do have it in my briefing, but of course, because I'm trying to find it for you, I cannot.
Would any of the plea paperwork or a judicial confession or records like that are filed with the court, is it the petitioner's position that would also be part of the record of conviction? Or are we just looking at the indictment and the judgment from your perspective?
What has been stated is listed out specifically, but it seems to suggest that all of the informational documents, so in the event there is an indictment, there is a complaint, which is tantamount in this case, I believe, to an information, all of those are the record of conviction. And that is my position.
Anything else? All right, thank you, Ms. Case. And I want the record to reflect that I've admitted exhibits 1 through 7, not just 1, 2, and 6, but 1 through 7. All right, thank you.
Thank you.
Mr. Potter?
May it please the board. My client has chosen to rest on the pleadings, but I would like to respond to a few comments that were made. Ms. Cates is correct that we do not contest the seriousness of the charges. All we are contesting is the intentionality element. And as we have fully briefed, intentionality is not a per se requirement of either of the charges to which he pled. Namely, it can be done intentionally, knowingly, or recklessly. And all we're saying is this is a summary process, compulsory discipline. This is not the normal grievance process which he would be subject to if this were, you cannot determine on the conviction itself that, that was an essential element of the crime, which it is not. Because it can be done these other three ways. Going back into the facts should require a full-blown evidentiary hearing going through the normal process. And that's all we're saying. We're not contesting the seriousness of it. We're not saying there will be no consequences. We're just saying that it's not this shortcut route to compulsory discipline. And going to the point on record of conviction, the case that the petitioner cites is a 1956 El Paso Court of Appeals case, Texas Insurance Company versus Curry. And that was dicta in that case because what happened was it could be used, an indictment could be used as evidence, impeachment evidence, but not for the truth of the matter asserted. Cases are legion on the proposition that an indictment does not prove the truth. They're allegations by a prosecutor, and it's ultimately not what he pled to. And what he pled to could be reduced by attempts to the lowest degree of felony that he actually pled to. So all we're saying is, look, these are not essential elements of what he pled to. Intentionality was not. This should go through the normal grievance process, not this summary abbreviated, we come to Austin and, spend a bit of time going through it. We go into the facts, not just the judgment of conviction. So those are the key points that I wanted to make in rebuttal. I know that we rested on the pleadings, and out of an abundance of caution, because I think this is a new process where we rest on the pleadings, in our briefing on the Asasi factors, and of course we fully briefed both the intentionality elements of both offenses to which he pled, not what he was accused of, because he pled to, something, at least one of them was totally different. So we also briefed the 180 days that he served as a condition of probation, and the board has already made clear, and I appreciate the concession from Ms. Cates that yes, the statute actually does say that, that it's fully probated, but there's actually a case that we cite from the Board of Disciplinary Appeals involving Mark Murr, who actually had the misfortune of being in the AG's office when all that came in, but he served as a condition of probation 6 months, and the board has made clear that that is still a fully probated sentence. So once again, we're going to rest on the pleadings on that. I did want to rebut a few of these issues brought up in argument, and I also want to just ask, because it is a new procedure, do I need, because we're resting on the pleadings, and one of our pleadings on the Asasi factors is an affidavit from Mr. Herring, my client. I don't know if I need.
Do you have any exhibits you want to admit? Do you have any exhibits you want to offer?
I thought that they were already, but if I need to offer them.
That's what I said at the beginning. When you file them, that doesn't admit them before the board. That just makes them available.
Got it. Okay, then I would like to offer his declaration previously filed. as Exhibit 1.
I don't have any objections.
Nothing's been offered of which I'm aware.
Good point.
I would like to offer Mr.
Do you have a number on it?
Declaration. I have it listed as Exhibit A, but
Is
Let's give it a
it,
change.
I'm sorry?
I have it listed as Exhibit A,
All right.
Respondent's Exhibit A.
Respondent's Exhibit A is offered. Do you have an objection? A is admitted. Anything else?
No, Your Honor,
All
unless...
right, I have a question for you.
Yes.
A plea in a criminal case is a judicial admission. To what did he judicially admit? What did he plead to? Did he plead to knowing and intentional?
No, that is not in what he pled to.
He pled to reckless? Are you telling us that?
It's just, it doesn't say what it is, just that he pled to a
So
third
it had
degree
to
felony.
have been to either the indictment or the complaint that's been admitted into evidence.
Well, the accusation in the indictment is that it was intentional conduct, but that is not what is in the judgment of conviction, Your Honor.
Not asking what's in the judgment. I'm asking what the plea papers say. What judicial admission did he make to plead?
Nothing that involves intentional conduct.
Are you sure?
Once again, the indictment says intentional, but that is not what he agreed to.
How is that possible? That he didn't plead to an element of the offense? You have to have a center to plead.
Well, it's not there, Your Honor.
All right. Any other questions?
Well, what about as to the injury to a child?
Well, an attempt can drop it down to the third degree felony.
Correct. But isn't the injury to a child, isn't that just intentional or knowingly? Does that include a reckless?
It does include reckless.
Or the third
That's-
degree felony?
Well, the attempt would drop it down to a third degree felony.
But would the attempt drop down the mens rea requirement? Or would it just delete the SBI? Because I thought it was injury to a child, and that what was deleted, what reduced it down from the greater offense to the third degree was dropping the SBI, which is just the serious bodily injury, not the mens rea requirement.
But once again, this is not in the actual judgment of conviction, which...
Well, no, it says injury to a child. And bodily injury, it dropped the SBI. Okay. And I think that there was a conversation, maybe not, does the affirmative finding have any, the affirmative findings, do those have any import to what we're looking at here in terms of the intentionality?
I'm sorry, I'm not, the affirmative findings in...
Family
Family
violence.
violence,
Of family violence?
yeah.
Well, I think it would in a regular disciplinary process. Our position is that to go here, we're looking solely at the judgment of conviction, and it's conceivable that it could have been reckless.
Okay.
Okay?
Doesn't the judgment of conviction contain the finding of family violence? Did your client admit to committing the family violence?
Right, he did admit to, the injury to the child and injury to a pregnant person, but an essential element of what he pled to, it could have been reckless.
So is it your position that the board should ignore the court's finding that he committed an intentional act, even though that finding is in the judgment of conviction, which you admit is part of what we should be looking at?
Well, the judgment of conviction is what the board should be looking at.
Right, and that judgment of conviction contains a finding of the court that intentional act of family violence occurred. And it's your position that we should ignore that finding for purposes of determining intentionality?
Well, if he pled to that, then, and there's a finding on that, then it should be considered.
Factual question. Was the unborn child eventually delivered safe and alive, or was the abortion completed?
The child was born alive, and there was controversy over, whether certain conditions were related to this incident.
And just to give a little bit of factual background, the child was born premature and spent longer than 180 days in the NICU because of underdeveloped issues.
I wanted to ask you, I'm looking at the Locke opinion, and in that opinion, the court says we look solely to the elements of Locke's crime to determine if those elements involve the kinds of acts. It doesn't say we look at the statute. So can you help me understand, are we looking at the statutory language, or are we looking at the elements of the offense the individual was charged with and pled to?
Variation on that of what the respondent pled to, because things can change between the indictment and the plea, as in this case.
Is there anything in the judgment that reflects the defendant, the respondent, did not plead to the indictment, the charge in the indictment?
Well, other than, at least in one instance, it's totally changed.
And that's the injury to a child case, correct?
Right.
Let me ask you about the assault on a pregnant person. In that one, the indictment alleged only intentional or knowing. The state did not allege recklessly. Is the judgment in that case, does it reflect a plea to the indictment or a plea to something else?
Well, with the reduction, and part of the plea negotiations, which I was not privy to as a criminal defense lawyer, my understanding is that they considered it a lowering of the offenses and therefore could escape.
And I think there was a reduction on the injury to a child, but it appears, based on the exhibits that have been admitted, that the plea on the assault to a pregnant person that is a third-degree felony as charged. And so I'm just making sure I understand when we're looking at what was charged and what the judgment reflects, if that judgment reflects a plea to the original charge.
And my client's position is no.
All right, anything else, Mr. Potter?
No, Your Honor.
All right, thank you. Any rebuttal?
No, thank you.
All right. Very well, the board will take this case under advisement, make a decision in due time, and notify you as soon as possible. Thank you, and we're in recess.